Which one you is the Kabaddi?
15 is a single. I'm speaking to people.
Explain the sets of petitions.
Yes, Manoj. Manoj, there are two sets of petitions. One is qua disqualification. The other is the allotment of the symbol. Before we go into that, let me give your lordships a bird's eye view of what the issues are and why we are here, Manoj. Manoj, Bala Saab died in 2012. And Manoj, in 2013, Manoj, Uddhav Thackeray became the Paksh Pramukh of Shiv Sena. And Manoj, the organizational structure of the Sikh Sena was set up at that point in time. And that organizational structure was amended in 2018. And Manoj, in terms of that, as your lordship knows, Uddhav fought the election. And Eknath Shinde was part of that. In fact, he was a group leader. In 2019, Manoj, the election we won and he became a minister. Then, Manoj, what happened was that there was an election of an MLC, in terms of which, Manoj, some cross-voting took place. And suddenly, Manoj, 31 members.
Election of, you were saying election of?
MLC, Manoj. MLC, some cross-voting took place, Manoj. I'm just giving you lordship brief ideas to what we're dealing with. Some cross-voting took place, Manoj. And in terms of that cross-voting, we suspected that Eknath Shinde's faction was responsible for it. But suddenly we found, Manoj, one particular day, Manoj, that 31 MLAs, Manoj, shifted to Surat. And from there they went to Guwahati, all of them together. And Manoj, that means only the MLAs passed a resolution that we remove the whip, which is Sunil Prabhu, from the party, in the legislature. We appoint somebody else, Gogavale, as the whip. And we proclaim ourselves to be the leader. And Manoj, this resolution was passed by them only with the 31 MLAs. That 31 MLAs became 39 Manoj. And when this happened, they informed the speaker about this change, Manoj, that 31 MLAs had executed. And the speaker marked that copy to the governor. And having marked that copy to the governor said, now let's have a floor test. Well, we said, how can this be? These are only legislators. How can they act on behalf of the party? The party, the Paksh Pramukh is Uddhav, Manoj. The governor, Manoj, immediately called a floor test. As your lordship knows, at that point in time, Manoj, we wanted a stay. The stay was not granted. Then we resigned. Yes. And Manoj, the floor test took place and they came to government. So the fundamental question that arises for your lordship's case, in the lordship's case, can a member or some members of the legislative party proclaim themselves to have the powers of the party under the constitution, remove the whip in the legislature, appoint themselves, go to the governor, proclaim that this has happened because that they are the party, whether that falls foul of the law or not? Whether they can be disqualified on this ground alone. Why? Because your lordships have held in several cases that a person can be disqualified if the conduct of the such person from the circumstances of the case is that he has voluntarily given up membership of the party. Now, these circumstances that I will show to your lordships, and briefly I've told your lordships, obviously, Malaj, I mean, it goes without saying, without anything more, that a legislative agglomeration of 10, 13, 15, and this is happening now daily. Daily, Malaj, people are proclaiming themselves, moving. Malaj, it's like this. You get elected on symbol A, you move to another party, You come to Parliament on symbol B, and it is upheld. This has serious consequences on the very concept of representative democracy. It has serious consequences on the future of our polity. And your lordships, with the greatest respect, must decide this matter, because this is happening on a daily basis. One, and now what is, see the complication. This matter was moved in 2023. We're in 2026. In the meantime, new elections have been held. They have been elected. Had this petition been heard, this government could not have been formed. The Shinde government would not have been formed had the matter been heard. And everything is that is.
That, Mr. Sipal, you should take care of that to argue the matter. How many times you have been seeking?
But I have never asked for a date. I have never asked for a date. I have never asked for a date. Your office may take it.
Not Mr. Sipal, but from your side, the adjournments have been sought.
No, my lord, I'm sorry, my lord. We have never asked for an adjournment. Only on the last occasion, my lord.
Another underlying factor that Mr. Sipal is ignoring, that your contention will be accepted. The government not being formed validly is dependent on two issues. That the lease is heard and the lease is declared in your favor.
It can't be otherwise.
That's what
I'm just saying, if you look at the 10th schedule, it can't be otherwise. I mean, and this is happening, somebody gets elected from West Bengal, joins a party somewhere in the northeast, then becomes a member of that party on which he never fought an election, which party had no representation in parliament. Somebody happens to be elected from Delhi. Only the legislative members join. Nothing happens to the party. He is now representing a party on which he never fought the election. Now, if this is upheld, this is constitutional harakiri. This is the most undemocratic steps that with the greatest respect, no court will countenance. Because the foundation of democracy is representative form of government. Represented means that you represent a political party on the basis of which you've got a symbol, on the basis of which you got elected. That's representative democracy. You can't represent another party in parliament not having fought on that symbol and then claim that you are the party. So that's the issue. We're talking about the consequences. We leave that out. That's on the disqualification part. Then the question of symbol. Now, what happens thereafter is that they move the election commission on the 19th of July. This all happens in June. All these events take place from the 21st of June onwards. The floor test is in early July, 4th of July. And they formed the government. On the 19th of July, they moved the election commission. I'm just barely giving your lordships the flavor of the matter. On the 19th of July, they go to the election commission and they claim that they are the party. The election commission looks at all this and the election commission says, we are not going to look at the organizational structure because the other side contended that the 2018 constitution, which amended the 1999 constitution, the election commission said, we don't have a copy of the constitution. We don't have a copy of your constitution, so we're not going to look at it. Even though both sides have been appointed under the 2018 constitution.
Communicated to the election commission.
No, what happened was we gave the new office bearers, and according to us,
Constitution request to be communicated.
I agree. I'm just explaining, I'm explaining. Your lordship is right. According to us, we wrote to them on several occasions when new office bearers were appointed. And along with that, we gave the amended constitution. But in that letter, we did not mention that annexed is the amended constitution. Election Commission took the position, it's not with us. But both sides, were claiming their rights under the 2018 constitution. Both sides. Elections were held under the 2018 constitution. 2018 itself, he was appointed Eknath Shinde group leader under the 2018 constitution. Now the election commission says, I won't look at it. And your 1999 constitution is undemocratic. We just see what is happening. Is undemocratic. So we will not look at your constitutional structure. They are a majority in the legislature, and on the basis of that, they are the party. That's the second part, right? Well, that's what they said. Now, Manas, in the Shiv Sena matter before this court, and the constitution bench said that the political party is different from the legislative party. In Subhash Desai. That's constitution bench. That the legislative party is different from the political party, which is why Sunil Prabhu, who was the whip, could not have been removed by them. It's finding. Gogavale could not have been appointed by them. He could not have proclaimed. Because you can't, as a legislative party or a group thereof, don't claim to be the political party. That's found normally in Subhash Desai. So, Malaj, how can then the election commission only look at the legislative party and say that they are the party? The result was we lost the symbol. So that's the second issue, Malaj, a second petition that is before your lordships. Now I can, Malaj, take your lordship through all them. A list of dates, yes. How do you? At SLP 1644, we've given the list of dates. Let's kindly have a look at that. Item 1. Shiv Sena was founded by Balasaheb Thackeray in 66, who functioned as the Shiv Sena Pramukh until his demise in the year 2012. After the passing away of Balasaheb Thackeray, Uddhav Thackeray was unanimously elected as the Shiv Sena Paksh Pramukh in the organizational elections held in the year 2013. This is not denied by them that I was the Paksh Pramukh. And under the 1999 constitution, I am not the Paksh Pramukh. Because there is no Paksh Pramukh, because at that time, Balasaheb was alive. He was the Pramukh. So the results of the organizational elections are available on the website of the Election Commission. Now, Malaj, kindly see the website of the Election Commission, page 41, volume 3, page 41. This is a convenience volume which we've given to your lordships, Malaj. Can you give, my lord? It's in the computer also, Malaj. It's volume 3.
C.
3C.
Page 41.
Page 41. Malaj. Documents before the speaker, Malaj. I'm sorry, Malaj. Your ladyship doesn't have it. But this is there on the website of the Election Commission even today, Malaj. Justice Mona, ladyship doesn't have it.
You are starting from the documents.
Yes, Malaj. Because I'm, Malaj, correlating the list of dates with the documents. Well, the whole question is, Malaj. Yes.
You can read also.
Yes, it says, Malaj,
Hand over extra copy.
we'll give another copy.
Yes.
Yes. It's better.
We have got it.
Okay. All right. I'm learning how to use a computer, Malad.
I think big volumes.
That's right.
I can't tell you.
Yes. This is 28th of January, and this is on the website of Shiv Sena, of the Election Commission. Shiv Sena's party office bearers election program was declared on 17th December 2012 by election officer so-and-so, and nominations were invited to the post of Shiv Sena Paksh Pramukh, National Executive, Shiv Sena leaders and deputy leaders. The last date of receiving nominations was 3 p.m. on 12th January. There was nomination form received to the post of Shiv Sena Paksh Pramukh, 9 forms received for the post of Shiv Sena leaders of total, and 21 forms were received to the post of deputy leaders. All these forms were scrutinized on the 15th of January 2013 as stipulated in the election notice and were found to be in order and declared valid by the election officer. Election to the above posts were held on 23rd January at Shiv Sena Bhavan. Nobody disputes this. As per the program declared by the election notice, all the candidates were declared elected, and the election results were announced, declared, and forwarded to that. And your Lordship will see at page 42, January 13 to January 18. Just note that, Malaj. January 13 to January 18, Udhav is the Paksh Pramukh, and Malaj, Sunil Prabhu at the bottom are these deputy leaders. And this is sent by the secretary, Malaj, and this is accepted. So, Malaj, the election commission knows, Malaj, there's no way the 1999 constitution, the election commission is quite aware because there was no Pramukh. There was only a Pramukh there. Anyway, and they never asked us, look, how do you do this? There's a new organizational structure. There must be a new constitution. Where is your new constitution?
Just for one clarification. First, you are arguing the symbol matter.
No, I'm arguing the disqualification matter. Yes.
The leadership structure.
This is the leadership structure, Malaj. Now kindly come to the next date. That is 23rd of January 2018 to 27th February 2018. Similarly, in the organizational elections held on 23rd of January 2018. I showed you also the 2013. This is now 2018. Uddhav Thackeray was unanimously elected Shiv Sena Paksh Pramukh. Results of organizational elections were communicated to the Election Commission, provided letter dated 27 to 2018. This letter is available on the website of the Election Commission. Eknath Shinde was nominated as Shiv Sena leader by the Paksh Pramukh in 2018. Organizational elections. He consequently became member of the Rashtriya Karyakarani. The Shiv Sena party leadership is duly reflected in the letter of 27 to 2018. Speaker and the, let's leave that out. But let's kindly see the document now, which is at page 45 of that very compilation that is before your lordships. Page 45. I'll read that. Organizational elections of Shiv Sena were conducted on 23rd of January 2018 at Mumbai, and the information regarding the designations and names of party office bearers sought by your office, Election Commission of India, is being enclosed herewith in format for your record. Kindly, and see, Malaj, now who is elected. Paksh Pramukh is elected, and then 282 people attended, and then an extra 2 your lordships will find, page 48, Eknath Shinde is a group leader nominated by Paksh Pramukh. Right, Bharat? Now, this is in 2018. No dispute on that. They accept there's a new organization. It's the Paksh Pramukh who has nominated him. Election Commission does not dispute it. Neither do they. But Election Commission says that constitution is not with me. Therefore, 2018 goes, I will not recognize that. When there is no dispute between us. After 4 years after the election is over, this election is disputed. Now, kindly come to what the speaker said. There, no? Yes. Yes. Kindly see what the speaker says, and your lordship will find at page, which volume is this? 3D, page 76. Very interesting conclusion by the learned speaker.
This is the one year had.
Where he accepts Malat. No, not the old volume, not the old volume, the new one. 3D.
This is the impugned judgment.
This is the impugned judgment of the speaker, Malat. Thus, in view of the above conclusions, I find that the leadership structure of Shiv Sena reflected in the letter of 27th February, which I just read to you, right? Available on the website of the ECI, is the relevant leadership structure. So he accepts it. Relevant leadership structure, which has to be taken into account for the purposes of determining which faction is the real political party. The question whether which faction is the real party is discernible from the 2018 leadership structure is discussed in paragraph 112 to 131 of the present order. And he says the leadership structure so determined as the relevant leadership structure for the purposes of these disqualification petitions are hereby referred to. And in those paragraphs, he says, I don't have the constitution, so I won't recognize any of this. I'll come to that later, but I'm just indicating your lordships. Here he accepts everything. Then come to the next date, Mullahs, which is 4/4/2018. Page Mullahs, 4/4/2018, Mullahs, my list of dates. Serial number 3 of the list of dates. On the 4th of April 2018, a further communication was sent to the Election Commission of India containing details of the organizational elections held on 23/1/2018 and also the amendments carried out to the party constitution. The amended constitution also was amended to the communication, which he denies. And your lordships will find that now, so that we can show that, page 49 of 3C, which volume your lordship already has. Yes. Your lordship already has. This is this letter, Mullahs, on the 4th of April. Your lordships will find it on the top right-hand side. And Mullahs, the starting toward the end of the page, after the election procedure, page 50, page 50. On the right-hand top, you will find the date 4th of April. And at the bottom of that page, you will find the paragraph starting after the election procedure was completed. So after the election procedure was completed and newly elected national executive resumed on the dais, Shiv Sena Paksh Pramukh Uddhav Thackeray co-opted 4 leader and 12 deputy leaders under his discretionary powers as per article so-and-so of the constitution of the party. So they refer to the constitution of the party. Election Commission doesn't say, I don't have it. In 2018, the list of names of 4 leaders and 12 co-opted deputy leaders is also attached herewith for your record. Also, please find copies attached of the election procedure and results declared by election officer of Balkishan Joshi, advocate so-and-so, so-and-so. And now you will find, Mullahs, that in the structure, which is at page 52, Eknath Shinde is declared as one of the leaders. He is serial number 4 at page 52. Same thing as earlier, Malas. So that's so. Now come back to the list of dates, Malas. Or should we show what the speaker has said? Yeah, it's better I show what the speaker has said, which is volume 3D, page 68.
3D now.
3D, page 68, Malas. That's the order of the speaker. Para 96. My lord has it. My lord Justice Bakshi has it. Yes.
Yes.
After having considered the submissions advanced by both the parties on the question as to which is the relevant constitution for the purpose of determination of the primary issue, I have come to the following conclusions. As per Honorable Apex Court, if both the factions have submitted different versions of the constitution, not true. They are appointed under the 2018. We have given 2013, 2018. We say under the constitution they have been appointed. So where is the question? As per Apex Court, if both the factions have submitted different versions of the constitution, then in that case, what has to be taken into account is the constitution which was submitted to the ECI with the consent of both parties before rival factions emerged. But he was nobody under the 1999 constitution. Before recording further conclusions, I find it imperative to reiterate that pursuant to the initiation of these disqualifications, the Maharashtra Legislative Secretariat, by later dated 7th June 2023, requested Office of Election Commission of India to provide a copy of the party constitution and regulations of Shiv Sena political party, which have been submitted to the Election Commission of India and stand effective as on 21st of June. It is also pertinent to mention that in the said letter, it was specifically requested to the Election Commission of India that copies of all subsequent amendments, if any, to the Constitution be also provided. In response to the letter, Election Commission of India, wide letter dated that, provided a copy of the Constitution and rules of Shiv Sena as available on the records of the Commission. Further, with respect to the amendments to the said Constitution, Election Commission requested Legislature Secretariat to refer to order dated 17th February 2023, passed by ECI in dispute number such and such. Having perused the same, it has to be noted that the copy of the Constitution of Shiv Sena provided by the ECI does not bear any date or year, but as per the ECI, that which is provided wide there replies the only Constitution of Shiv Sena available on the record of the ECI with respect to the amendments, if any, to the said Constitution. The Election Commission wide order dated so-and-so has held in para so-and-so that the amended Constitution of 18 is not on the record of the Commission. How are they concerned with it? We went to the Commission agreeing that this Constitution or under this organizational structure, he was appointed by me. And if both parties are ad idem, that the appointment was done by me, where is the question of saying I don't find that Constitution on my website? Thus, the petitioner's submission that the Constitution of 18 has to be taken into account cannot be accepted, as I am bound to follow the directions of the Apex Court and accordingly take into account the Constitution, what the Election Commission has provided. In my jurisdiction under the 10th schedule, I cannot delve into any other factors while deciding which is the relevant Constitution. As prima facie, it is evident the record of the ECI, the 1999 Constitution, is the one in which was submitted by the ECI. So, that's the logic of the learned speaker. Now, let's come back to the list of dates, Maharaj.
We continue on Tuesday, Mr. Sujit.
Yes, very well. Deeply with that.
We can do one favor.
Yes.
Yes.
Prepare a convenient compilation
Yes.
for a document 3D to 5D.
All right. We'll do that. We'll do that.
We can have one compilation.
Certainly, we'll do that.
That will help.
Make it easier, Maharaj.
Make it easier for you and definitely for us.
Yes, certainly. Deeply obliged. Deeply obliged.
With my lord's permission, may I make a request, Lordship? Well, the item number 107, this is the original suit of 2 of 96, Lordship. Well, there is, a decree was passed in 2011. Now, Learned Attorney General has submitted a proposal, Lordship. So, my lord, if it may be taken up today,
Just after fresh.
just after, please, your lord.
Then item 14 on my lord's list.
Take up after the fresh matters are over.
Please, your lord.
Only in the afternoon, I may have some difficulties after 2
No,
o'clock.
no, we will take up it today after the fresh matters.
Very well.
Before noon.
Very well.
Before
Very
I'm deeply obliged.
Well, as in item 14 on my lord's list today, Mr. Gopal Shankar Narayan is leading me in the matter. Today, he has some personal difficulty. I'm only requesting for an accommodation today. I would have circulated a letter. I apologize, but I came to know very late. I could not circulate a
You're
letter.
the opposite side here in that.
I'm,
This is the arbitration batch of 3 matters.
please, my lord. It's just because of some personal difficulty. Otherwise, I would not have bothered to mention it.
We are the opposite side. We are embarrassed because the award in one matter, extension of time. Award has been passed and our time for filing 34 will expire soon, although there is some time left. So either
My lord,
Lordship allows us to open today, but your Lordship will be truncated. Or my Lordship may put on Wednesday 5th, not
Please, my lord, on Wednesday.
personal difficulties, so I will not, my lord. 5th, your Lordship may accommodate us, my lord. Wednesday.
Wednesday.
short.
Because there are 3 matters. In one, the award has been passed, my 34 will have to be filed. They are already arguing award is passed and fructuous.
Because it's MSME, I'll have to deposit the amount.
3 matters there.
Those may have it on a short.
Try to accommodate next.
Possible 5th, we can request only.
We'll try to accommodate next.
Obliged.
Please, I'm deeply obliged, my
We'll
lord.
see what can be done.
We have placed on record the order copies of the earlier batch. The same facts. There also your lordship's court said, civil proceedings will take care, whatever relief we can claim there, it will be followed.
Let
him come and answer what
Yeah.
petitioner should also become the best.
Your lordships are engaged in a Samadhan Samaro. I think the ideal case for being.
Got the proposal and the attorney general has given.
Well, we accept the proposal. We want to buy peace, Malad. We want to.
I'm appearing for Punjab. I'm appearing for Punjab.
Program is proposing everything on the earth.
No, Malaj, here, Malaj, I will show. Malaj, I will demonstrate. I'm for Haryana, Malaj. I'm appearing for Haryana. And Malaj, we will.
First of all, tell us, none of you have any objection after I am hearing the matter.
Absolutely not. In fact, we are very happy. We'll be very happy because well, the topography by laws, nobody can understand better than by laws.
In any case, I will hear so long as there is a possibility of settlement. Otherwise, we'll send it to some other source.
Malad,
Our concern is this, Malaj.
we've been not getting 13 million units, Malad. Since, Malad, we need to get electricity. And the government and the country will benefit because we'll export it. We'll, whatever we need.
Yes.
And the attorney general has acted as a mediator virtually.
Malaj, may I tell your lordship very broadly in 2 minutes what our concerns? Your lordship's decree, Malaj, of 2011 is very clear.
So if we will go into on merits justification of what he has proposed, then they might have some certain things to say. Haryana will also have certain things to say. You had definitely something to say.
Yes.
But when the question of give and take comes, and you want to resolve amicably, after all, you are all 3 sisters
Yes.
or brothers, whatever way you want to call.
Unfortunately, estranged occasionally.
It's the younger one. Only 71.
Youngest.
Better treatment to those who born in 66.
But my lord is right, Malaj. But Malaj, the one who's younger can't at that cost, Malaj, completely destroy us. And I will show, Malaj, that both on both facts, and your lordship is right, Malaj, we are willing to give more than we may be entitled to under the decree. But the core 3-4 issues, Malaj, number 1, what are the units you are entitled to? Number 2, what is the capital cost on that date when the project is completed? Number 3, what is our interest payment and what are the O&M charges and which rate is to be applied? These are issues, Malaj, on which if we concede, Malaj, or if we settle to the proposal given, Malaj, and I must say the attorney has put in a lot of time, Malaj, we've all spent time with him. But Malaj, there are key concerns, Malaj, and it is our respectful submission that it goes in the teeth of the decree, Malaj. And I will demonstrate to you it is contrary to the act, it is contrary to the decree, Malaj. And we are not saying we want the entire piece of the entire cake, Malaj, but something fair, Malaj, or thereabout. And the reason why what we suggest is correct.
State should be also ready to face the consequences. In case we don't find any merit, then there will be very serious consequences. When we may not agree with what many attorney is asking, there is a decree in their favor. There is a decree in their favor waiting execution since 2011.
Correct.
Then all consequences will follow.
Well, it's,
At the moment, we are not even asking for interest, Mullah. We've given up 6%.
One of the states will oppose. They also have a right to wriggle out of it. They will also not agree with this proposal. And in that case, there is a pay to comply. There is a decree of 2011, and then we will execute the decree, and we will execute through the nose of the state's majesty. Then we know how to use our power, because we will not allow a decree to become a paper empty decree. Then it has to be given effect.
my lord is absolutely right. Well, the decree says.
Because your state, unfortunately, is in habit of defying court decrees.
Well,
You have an old habit, and habit die hard.
And if you lordships will kindly
That's
say,
what I would like to say.
The decrees, millets of rights and liabilities of the state of Himachal. There are liabilities to be seen.
We have indicated enough. The choice is to either an amicable settlement or execution of decree. You make up your mind and tell us.
only one.
One I
small-
said at the outset, we are happy to settle, Millet, but must be something reasonable. Man. I will show to your lordship, Millet, how
One is way of settlement, because despite strange in relations,
Yeah.
you are still common asset.
absolutely.
Your Bakra Nangal survives only when the water flows.
Yes,
Water comes from their, passes through their land.
yes.
They don't have any other asset except this water passing through theirs. They survive on that.
Yes.
You have, of course, certain other sources of survival. Haryana too has some other sources of survival. You can still afford, but may not be a poor state like this.
As well as, but Millet, the decree can't be
But at the
completely
same
negated
time,
in the process.
Not that they should also be unreasonable.
I agree, Millet.
Today, they have a decree in their hand. They are saying that this court has vindicated their stand.
Millet, may I just on that say,
Questioning that whether the fruits of that decree can be deprived.
the decree is, Millet, that all rights and liabilities of Himachal should be assessed. Now, Millet, when, may I just tell your lordship our main
But
concern?
setting off the claim today, which were never put up before the decree.
Yes. No,
You want us to now argue on merit?
No, Millet, the court has noticed it. It was there, Millet. The court said this aspect we are not touching.
But today you are saying that they are liable to pay because their buses have crossed the Punjab, therefore they are liable to pay.
No.
Their human beings have crossed from Punjab side, therefore they are liable to
The
pay.
Reorganization Act of
Where is that
66.
claim set up before the court?
Millet,
Should have been part of the decree.
yes, Millet, the decree says as per the Act of 66 says that whatever the capital cost of these projects and the interest, salaries, that have to be paid by them in proportion to their share of 7.19%.
That's all discussed, Mullah, and the central government has given the money. It's not their money, Mullah.
Sorry, now we have put on record.
Therefore, let's be clear on the facts.
Having said all that, we are very happy to settle on something reasonable, Millets, where we can't, Millets, we are not cut off completely. The rate which is being suggested, Millets, is a rate never paid by any party. We had suggested, all right, we will give them these units. Let it be what is called an O&M rate. On the O&M rate, Millets, is the rate on which they have purchased all along. We have been supplied all along by BBMB. So apply that rate. Now, Millets, the rationale given, Millets, in the affidavit of the union in rejecting that rate is that no, then Himachal will have to pay some money. If that is the rate, Millets, that is the correct rate, and you are liable to pay for the capital cost, which you've never paid, all through from Millets, from the inception till Millets 2011, they have all along been given 2.5% of the electricity. They have not paid a single rupee to its capital cost, which was in tens of crores, Millets, which has grown today. So, Millets, I'm just saying, let us go by the decree, but if there is a fair settlement, we are absolutely ready, Millets. That's fine.
And argue the case.
Millets, we are ready to settle, Millets. I'm again saying this. Let us sit together to something reasonable.
Now
and let
that
us-
my learned friend,
15
has-
If it is not acceptable, then argue the case. We will hear it on merit.
may only suggest it. Now that my learned friend let his full steam off and
There's no pulse.
no, the note in fact catches everything that has happened after
Yes,
your
yes.
lordship took note of the matter. I had several rounds of meetings. Meeting took place at the highest level. Then the only way out was if you talk about capital costs and things like that, then there has to be a cash liability or a monetary liability. But that was not working because Himachal has some difficulties. Government of India looked into all that. Therefore, we have suggested a cashless settlement. If the 13,000 units, now we slash it down. If you're a longer period, bring it down. or bring it, make a longer period. That's how the settlement works. So though we need to go beyond the Reorganization Act. Otherwise, the Act will always confront you with a settlement purpose, which will never happen. Therefore, this note, in fact, says everything about that matters. And
So far as the state of Haryana is concerned, the only sticky point was whether the capital cost to the entire project is to be shared or not. That is being taken care. So in principle, my instructions are the state of Haryana is agreement. When this is to be implemented, we should,
Can still believe,
yes.
we can even to that extent, we can presume that there might be some element of unreasonableness toward Punjab or Haryana. It
Please,
can be.
yes, yes.
I'm not saying so.
Please, Manoj.
But then when question of give and take comes, when question of relations between states.
So there's no difficulty, only
Long-term projects come.
we agree, Manoj, we agree on that.
Prestigious projects which are
Yes.
combined and which cannot be segregated
That's
by
right.
virtue of their very nature of the project.
Yes, yes.
Those
We,
have to be run
no,
together.
we from Haryana, I have instruction, we agree principally on this. We should be allowed to participate in quantification process to be worked out. At that time, if we have any issue, we'll raise it. Principally, we are in agreement with this note.
And the Attorney General has been very kind, spent long hours, Mulaz, to resolve this issue. And I think it's an excellent draft because it takes care of all
Now
their
there is
concerns,
no need
including
for a-
capital cost and
no need
operational
for a
maintenance
monetary
charges.
computation. We are reducing everything to the units and the duration.
Electricity
Yes.
change.
So no money has to be exchanged.
No money has to be exchanged, Mulaz.
Look at it to government, whatever they, if they want to reconsider, they can reconsider. Otherwise, we will hear it.
I'll push.
We have no choice, we have to hear the matter.
Yes, yes, I agree. I'll put it. Manoj. Yes, I would just say, Mulaz, that the decree is go as per the act. And Mulaz, in that,
Yeah,
liability should be factored in. And the liability, the actual liability based on balance sheets approved by the CAG.
We were together.
And if Mulaz, a rate is being applied, which is a rate nobody has ever paid. The Union of India's suggestion is to give the rate, Mulaz, which is a rate which puts us down by 2,000 crores, Mulaz. That's a rate nobody's ever paid for that electricity and then calculate electricity based on that. So we have no problem, Mulaz, giving units. That's not a difficulty. But on what rate, Mulaz? An NFL rate, Mulaz, is a rate which is never paid by any party.
Reduce the number of units.
Yes, then we can, that's what I'm
That's
saying.
what we have suggested.
But the units, Mulaz, we are willing to sit again, Mulaz. I would sit, Mulaz, again with the attorney and I'll place our case, Mulaz. And we can sit together. We reduce it to something reasonable, at least halfway, Mulaz. Here I would demonstrate, Mulaz, we are facing the brunt of it.
No, the brunt is essentially that they want some money on their hands.
No, I'm not saying that. We will give units.
We were part of Punjab, remember? We were part of Punjab, then we became part of Union territory. So I don't know what my learned friend is getting at. And they spent no money, but as loan from government, not paid back to government.
Not correct. That's not correct.
That's the capital cost they're talking
Mr.
about.
Sibal is right.
It's a loan from the union, not paid back to them. And he says, give me capital cost.
And we were part of union at that point of time,
Yes.
as union territory.
So it is.
In fact, I
Our
asked the
money.
Bakra board to give me details of calculation, profit, capital investment, then interest, so on and so forth. They went into all those details and ultimately found out you had asked Himachal to pay some money. Then, of course, there's a question of monetary liability by the Himachal state, and they have to probably borrow from somewhere. And that's what we thought, instead of monetary compensation, go into a calculations on the number of units. That's the best way of going about it.
Exactly.
And any other argument will take us back.
No, it will not be resolved. It's 15 years have passed, Mulaz.
This effort
Is the
being
decree.
made now. We are involved now.
We have heard the arguments briefly with respect to the proposal submitted by Nyaya Sanhita for India. While the state of Bharatiya and state of Haryana have resisted, agreed to the proposal, have agreed in principle to the proposals. On a state of Punjab has raised a decision. In the interest of justice, this time is granted to the state of Punjab
Specific date, specific date.
to reconsider its stand. To reconsider clarified stand. For which the matter shall now be taken up in consideration. Chapter 2, which on 12th August.
My lord.
Please, Your Lord.
Deeply obliged. That page, which is that page? No. Order, simply order, page 26.
17, para 26.
My lord, please come to page 26, para 17. If this was my lord's order, then I'm wrong. And I'll show to my lords that my lords had said, you argue your striking off first, and then what remains then can be discussed in 711. That's my lord's order, bro. Now, para 17, it says, with regard to the allegation raised in para 7 to 12 in the election petition, with regard to the improper acceptance of nomination paper is concerned, though the election petitioner has not given any specific particulars. Pausing for a second, my lord. The only allegation is that this is the law. No antecedents, no suppression, nothing pointed out, my lord. Only that is the only pleading, my lord.
Election petition, we also move further.
So it says, with regard to assets and criminal cases pending against the returned candidates, it is relevant to note that whether he had disclosed his entire assets in his name and his family's name, member's name, as well as entire criminal antecedents could be established only at the trial, not provided you have mentioned something that is missing. There's no mention at all. I'll read that to my lord after this. The assets and the criminal cases are well within his knowledge, and only when the returned candidate is confronted to trial, these details will be unearthed. But disclosure has to be an omission or a commission. I mean, I have to be deliberately suppressing something. If I suppose I have given a disclosure and you have nothing against that disclosure to communicate, that is, how can that be a ground? I have to speak lies or suppress some facts from form 26 to be made liable. And this is on my first point itself. Please see, now what is that? Please see the pleading. Pleading is that page 94, my lord. 93, 94. I'll just read. This is the pleading, my lord. The petitioner submits that the first respondent had filed his nomination on 25/3/24, and the same was uploaded in the website of Election Commission and was scrutinized on 28/3/24. The petitioner submits that the first respondent returned candidate had suppressed the information that he is mandatorily required to furnish under the provisions of Representation of People's Act. Section 33A2 of the Representation of People's Act makes it mandatory on the part of the candidate to disclose all criminal cases against them. The petitioner submits that the first respondent is bound to provide information about his criminal antecedents and the assets owned by him and his spouse along with his nomination paper in the prescribed form 26 and 4A. The first respondent deliberately suppressed the full information. As such, form 26 filed with the nomination paper is defective in substance. The petitioner submits that the false declaration relating to the criminal cases filed against him and the assets belong to him are substantial in character, and his nomination ought to have been rejected on the sole ground of suppression. The petitioner submits that the first respondent, along with his nomination form, submitted under Form 626 and 4A of the Conduct Rules, respondent number 1 has suppressed his criminal antecedents, the properties owned by him, and his family members, as well as his educational qualifications. The failure to submit the aforesaid particulars in entirety amounts to corrupt practice. No, but where is the material particulars? This is what he's quoting the law, and he says, you are bound to disclose it. I have disclosed it.
One aspect of the election petition.
I know.
Several other-
I'm on those points where we said this doesn't make out a case. You have to make out a case with material particulars and material facts and particulars. You're only quoting the law and saying that you have not disclosed. Next.
Other allegations
Yes,
also,
other
there are
laws.
so many of them.
No, my lord said there was
Trial.
my lord had made a direction to consider the application, Order 616, and see what can be deleted or what cannot be deleted. And prima facie, my lord said that seems to be some substance in what we are saying at that time, which is my lord's order, para 5. Now, see the next ground also. Votes not counted due to failure of erasure of mock poll. This is page 108. 108. Now, 108, well, what happens in the election? First 30 minutes, you are supposed to do the mock poll. Sorry, there is a mock poll done by these machines. Generally, it is expected that after the mock poll, you should delete those figures so that when the same machine is used for election counting, the mock poll figure should not be there. In two machines, by mistake, those figures not deleted. So they found that in two machines, 582 votes and 615 votes were polled. Now, the law as given out in the handbook is that if at the end of the day, these figures are much less than the margin figure, then it is excluded. And that is what there was no mistake. The margin of victory was more than 4,000. Assuming we add these two, it's 1,000. And that is what the RO has done. So he's followed the handbook and kept these figures out. Now, assuming that you even add those figures, it doesn't go more than, it only reduces the margin by 1,000, it will be 3,000. So how can this be a ground? What I'm trying to say.
Matter for trial. Again, this is a matter for trial.
What is there to try? What I'm saying that trial is when there is a cause of action.
There is another facet, if Allah shall permit me, I'll not repeat. The facet is this, fellas. How do I change and file an affidavit truncating, as I said to your lordships, without the other person truncating his grounds of challenge in the EP? That problem is arisen practically. My lords were told, first by me, second time I didn't appear, fellas, that we will file an affidavit giving these specific objections to ABCD. Now, I can do it only if he truncates his petition. I cannot in the first place truncate my grounds of challenge. That is the problem I'm having. If only my learned friend will indicate which ones he will truncate, I will do the same. And the court can decide. The second problem is the impugned order appears to have repeated itself in the last round. And kindly see this comparison chart. It's virtually identical. They have again copied and pasted their earlier order, which was not your lordships and could not have been your lordship's intention of remand. Just see this identity of chart, fellas. This identity chart? No, the identity chart. No, it's wrong. Identity chart. Earlier order. Earlier order in the current.
All of this will only show that this will necessarily require a trial. Matter, I mean, you are there. The trial will be completed on time.
I understand, but fellas, the new order virtually copies itself again. Will you give me that chart? Is staring at my face? Well, the new order repeats itself almost identically. And very well, but let me just say this. Your lordship's two orders are 21-4-25 and a clarification order later. Now, in those orders, my lord says, I will limit myself to the grounds. Right, fellas? I say that. Well, how do I limit if the election petition doesn't limit his grounds?
You have filed both the petitions. You have filed order 6 as well as order 7. You will have to choose one after the other. You could have either filed rejection in the existing pleadings, or you could have filed an order 6 to remove strike off certain pleadings. You filed both simultaneously.
That was the case in the earlier round also. Earlier round also it came on that only.
You were permitted to strike off, file an amendment in the earlier order.
No, that is the problem. That is the problem. I'll explain in a second. We were allowed in the first round. Would my lords turn to the order of my lords on 21 April 25? Just see, don't have it. Huh? The chart you gave me was the identity of the first order and the second impugned order.
This is here on similarities.
Have you given this? Is this the same? Similarity.
Give this.
Well, it's 2 points I'll make. I won't take your lordship's time. Just your lordship's order of 21 April 25. My question to myself was, maybe I'm wrong. Your lordships, we had a fair intention. Just see para 6. Para 6 of that order of my lords. So-and-so learned senior counsel submits that instead of pressing all the original grounds in the application under 711, the appellant shall submit an additional affidavit restricting the ground which he now proposes to plead before the High Court. Now, I cannot unilaterally restrict unless certain grounds by him are restricted is my first point. My second point is this note. Can I give this note? You've given this? Well, I have given a similarity chart. I don't know why my learned friends don't carry enough copies. This is a beauty of-
Already do that.
No, that is a wrong chart given. That's another error. If given a Rosh, please ignore that chart.
That is
My
what
learned
cause of
friends are
action.
well,
That's what the
complicated.
cause of action.
We are having enough difficulties without these problems. Kindly give at least one more copy out of 3 judges. At least 2 judges should have it. I'm sorry, 2 out of 3 will have it. See the bottom. Page 2 of this. Page 2. That is the wrong chart. Please ignore the first one. Kindly see the second. Similarity chart is this, fellows. Now the learned High Court, fellows, virtually copies its earlier order, which your lordship remanded back. I've given it, fellows, in text. There's no real application of mind. See the page 2 and 3, fellows. It starts at 2 for each, for order 6, rule 6 and also order 7, rule 11, both. But there's a direct, fellows, there's no application of mind. They just do it in a routine way.
But since 2 years have already passed.
As I can't say anything more. Your lordship has given me a fair, very, very fair hearing third time round. In fairness, I should not complain. I should not complain. Well, only one thing, your lordship, while disposing it off, fellows may say that nothing of this affects the merits in any manner. I have come twice to your lordship on those technical, nothing should affect. These very grounds arise in the main merits, as Justice Mona says, well, they'll arise in the main matter also. So they should not affect those merits.
In fact, when they frame issues, they'll have to see whether cause of action is there. And you can raise it at any framing official.
Do say.
So the petitioner shall be entitled to raise all the contention.
Yes, yes.
I put at a
Very deeply obliged. Very deeply obliged. I am responding to Malas.
May it please your lordship. Lord would recollect, it's a matter. Lord, just allow me 1 minute, my lord, on a little background. I am a debtor.
I have a kind of a preliminary
My
objection.
industry was in a stress. Lord, I offered an OTS of 235 crore, 238 crore to the SBI Bank. SBI Bank didn't agree. After about a year, they assigned the loan to this ARC at the without giving me an opportunity.
Yes, there is a preliminary point. Copies of it. There is a preliminary
So,
point.
Lord,
Preliminary point.
hold on for a second. So, my lord, it was assigned to them at 250. I came to this honorable court. It was a running industry, about 700 employees working.
You can't go into now all these very.
Correct. Lord, in fact, there was a consent order passed by this honorable court. I want to invite Lord kind attention to that consent order at the suggestion of Dr. Singhvi, 9th of December 2024 order. Lord, may kindly see that order, whereby the reference was made to Honorable Justice Anil R. Dave to suggest that, all right, 250 they will deposit. But what should be the rate of interest over and above the principal amount I was required to deposit? And if cost, if any. And it has been suggested. Just permit me to read that order, my lord. Para 1. 9th of December 2024 order, my lord.
Circle the
It's a short order, my lord.
account statement as of today. Today. Or 1 month ago, 2 months ago.
January, it is 56.
Please, my lord. Vide paragraph 2 of the order dated 20th of September 2024 is scheduled for payment of 250 crore by the petitioner company to the respondent who was laid down.
as there was some dispute with regard to the total liability of the petitioner over and above 250 crore, it was suggested that let such liability, if any, of the petitioner company be determined by a judicial or quasi-judicial form, of course, subject to the final approval by this court. Learned Senior Counsel for the parties jointly state that the third installment of 50 crore, which was payable on so-and-so, has also been paid by the petitioner company. Adverting to the suggestion given by Dr. Abhishek Manu Singhvi, the Learned Senior Counsel, and in deference to para 3 of the aforesaid order dated 20th of September 2024, we resolve to appoint Honorable Mr. Justice Anil R. Dave, former judge of this court, to adjudicate the claim for, Lord, may kindly mark this, for interest and or any other liability over and above 250 crore. We request Honorable Justice Dave to permit the parties to submit their claims in writing in this regard and thereafter accord one opportunity of oral submission. So, my lord, we went there. And the Honorable Justice Dave, my lord, we brought just one more fact before Honorable Justice Dave, that this 250 crore, the day it was paid to the state bank, the same day, the same amount was received by this ARC from my competitor in the market, Simco Winme. Those facts were taken on record, put to them. They did not respond to those claim by me.
For us, that may not be relevant. What is relevant is what Justice Dave says now.
Yes. Now, my lord, may kindly see the report. Lord, I would humbly submit, so far as other costs is concerned, Justice Dave has quantified as 50 lakh over and above the interest Justice Dave has suggested on the amount of 250 crore. The, my lord, the ultimately calculations are given. Para 49. My lord, para 49, Justice Dave gives the calculation after hearing both sides. And my lord, ultimately there is a, pardon me, this report is dated 9th of July 2025.
Just close it now. He wants to close the case.
But Lord, it starts from para 36. The consideration starts from para 36, Lord. And ultimately, Lord,
In each paragraph, in the instant case, the Honorable Supreme Court by an order dated so and so has appointed me to adjudicate the claim for interest and or any other liability of the petitioner. Over and above 250 crores, taking the following paragraph also.
True, my lord, and para 49 are the ultimate calculations given. So there are three calculations given. If the rate of interest is taken 13%, then is the X amount. If it is 14%, then the X plus Y amount, and then 15. So it has, Honorable Justice Dave has left it to this Honorable Court to apply the rate of interest. But three calculations are made.
48 is also relevant.
That's right.
Accountant,
25.
whose assistance I have awaited, has calculated return or interest on the actual outstanding amount payable by the institution to the company because
Page. Page 49. Which volume?
Checks every minute.
No, this is a separate volume of yours. Page 49. Page 16. Independent. Independent
volume,
volume 14. But actually, page 16. Page 16, volume 14. Page 16.
Not 49.
Left side. Para 49. Page 16, volume 14. And started injuries.
Why do you tell me now?
Abhi fixing price.
Para 49.
At the rate. It's clear. Hey, yaar, once the report is there, you have to do back calculation and be a second just the way. The whole idea was finality here. You are constantly. On the matter end.
250 paid, that's it. 13th of January order records that. Things to say.
Can I?
Admittedly, this ARC has taken there is no dispute. This ARC has taken money from a third party on the same day. That has been captured in para 34 by Justice Dave. And the rate of interest.
That is not relevant now for us. From where you have taken money or they have taken money.
But the question is, now the rate of interest being suggested, I humbly submit, is on a higher side. Because
The
2023.
point is very simple now. After payment of 250 crores.
That's right.
Justice Dave's report says if 13% interest to be awarded, then this much amount.
Correct. That's
If
right.
14% interest is awarded, then this much amount. If 15% is awarded, then this much amount.
And over and above 50 lakh has cost.
Litigation expense.
And over and above 50 lakh has their litigation.
Now,
Less expense.
I have, my learned friend need not quibble about 13, 14, 15. I have a serious preliminary objection. With the greatest respect, Wallace, to Justice Dave's report, your Lordship's two orders, 20th September 24, which he has not read, and 9th December 24, which he did read, but not the relevant portion, which I'm going to read, made the terms of reference clear on one thing. The total liability of him to me, please calculate that. That is total loan, interest reduced by receipts and payments. What is balance? Your Lordship used the word total liability in 3 orders. Learned Justice Dave Wallace, in the calculation, says that what I have invested on that, let me find out the return. He takes complete leave of your Lordship's terms of reference. That's the main problem here. I am suggesting we should go back to him and point out that what he has done is, he has said, I purchased the debt, which was 0 at that time, at 250 crores. What should be a fair return on 250 crores to me? The liability in January 2020, give me 2 minutes on these figures. Liability in January 2025 was 460, in April 2025 was 463 crores. A valuer, which is Supreme Court approved, has done that. Now, no, he changes your Lordship's terms of reference. I can't balance your Lordship's terms of reference are clear in the order. Secondly, the problem is, my learned friends, your Lordship, in good faith, we went into this. Your Lordship directed pay 250 crores. He paid it 7 months later. Your Lordship, remember those hearings in the other court your Lordship was sitting, we were appearing 7 months ago.
They are liable.
No, not only liable, but
That interest we are
kindly bear with me.
interest.
7 months after your Lordship's. Now, in the meanwhile, in your Lordship's I'm sorry.
Because I couldn't see.
In the meanwhile,
That we imposed a kind of penalty or interest of 15 crore on them, and they have paid that.
they have not paid that, first of all. They've not in this case. I'll tell you what you should do. Give me a minute. Your Lordship's extended time with severe warnings to him. Second time again, he did not pay. But this is very important. Mr. Atibir's liability is forgotten. But how is it that his liability, he's a defaulter, he's a loan taker, how is his liability forgotten? We find that except the offer of total amount of 250, the rest of the proposal being just and fair can be accepted to save the running industry. Regarding the total liability, mark the word total liability.
I'll get Gujarat 15%. Don't talk about forget Gujarat. You don't talk about it.
Only interest on.
Next sentence. Regarding the total liability, the same can be determined by a quasi-judicial forum. That's how your lordship sent it. Everybody's forgotten this phrase. And then we agreed, Wallace. Now turn to the second order. 9 December.
Yes.
The first principle is the lordship's demand. So I am happy to argue it here on a proper date and show the errors. Or your lordship will remand it, either way. Page 2, well, para 1 and 3 of your lordship's order of December, which management read. But the real para is 1 and 3. Here you are just adding. Does my lord have it?
Yes.
Vide para. So in para 1, my lord repeats the order. Vide para 2 of the order, a schedule for payment was made. Second sentence. As there was some dispute with regard to the total liability of the petitioner company over and above 250. So what is it? He owes above 250 how much? That's the total liability. It was suggested that let such liability, if any, of the petitioner company be determined by a judicial or quasi-judicial. Now comes the third para. We resolve, third para, to appoint Justice, Honorable Justice Dave, former judge, to adjudicate the claim for interest and any other liability over and above 250 crores. And then para 6, consciously not illustrating the issues. Now just see page 16 of Justice Dave report. He doesn't do anything of the sort. But he may not be wrong, but there is a serious he was unwell in between also. There has been a gap. There has been a gap. We will go and go to him and very respectfully show him. We have otherwise very high regard for him. Well, this
Very embarrassing for a former judge who accepts on our asking. Whatever issues are there, we can resolve.
your lordships can now see.
Lord,
I
the
have no
same
problem.
thing was said
Then
before
your lord-
Justice Dave. I was there.
We have filed,
Mr. Singhvi
Bharat.
was not there.
We have filed-
They said total
Sir,
liability,
there is
but
no
was
question
due
of
to
not
the
here. I've been
bank.
here in all hearings.
And
You may
we
not
have
be
to
there.
claim that.
Now-
That was
now,
all
Bharat-
said, argued.
No, can I finish? No, just read what
Note of it and fortunately could mention in the order.
page
We
14.
said that not only the parties will submit their claim,
Yes.
they will be heard also.
Yes.
That's what we request in this.
That is the error, Malaz. Now see, Malaz. What has happened here? Just see page 16, then I'll tell Lordship the error. Justice Dave's report, page 16. Justice Dave's report, Malaz, page 16.
The paragraph of the report.
Last page. Last page.
Last page.
Last page of the report. There's a separate volume of the report. There's a separate volume of the report. What the learned Justice Dave has done, Malaz, is he takes 250 because that was the price I paid
SBI.
and then lent to him. Now, having taken 250, now see what he does.
He has not lent me anything, Lord. The bank had lent to me.
That's all right. I purchased the debt.
He just purchased
I
it.
purchased the debt as the same thing as lending
Took the
you.
money from
What is
my
the difference?
competitor in
Now
the
come
market
to-
doing the
well,
same
management
business.
may not interrupt me. If I purchase the debt, it's as good as me lending you. I step into the shoes of the lender. Now, let's kindly come to the. He gives a return on investment, simply takes 250 and says on 13%, 14%, 15%. This is nowhere, Malas, the issue.
The issue has been considered. Please come to the earlier paragraphs. They take notice of the amount, initial OTS offer,
Yeah.
thereafter your offer, how the amount of 453 has been brought down to 250 for you.
Yes.
And then 250 you pay and get the data assigned.
Yes.
You don't want the data to finish it off in 250 crores.
Correct.
If it can be assigned for 250 crores for somebody, a third party purchaser,
correct.
why can't the same 250 standard be applicable to the debtor?
The reason,
Paid by virtue of this court
the
order
reason-
in time.
No, therefore, the reason is
That was assigned, all that was requested to Justice Dave was you find out what is over and above 250 for the company to have offered to this bank for the settlement.
now, Malas.
That's all has been arranged. It's a very detailed considered order.
Malas, that
They're all heard.
a statutory regime of ARC was created that a person who takes a risk and invests 250 will, Malas, expect a much higher return.
That's what has.
That Malas, therefore, Malas, then your lordship, Malas, then your lordship do one thing. Kindly, Malas, instead of sending it back to Justice Dave, kindly give me a short date. I've got a 25-page written submission already filed. I want to read some parts of it. That's it. I have a 25-page written submission already filed. I will, Malas, read some. I've titled. Let me argue that before your lordship. Let me not go back. Yes. I will make submissions on this, fellows, which is already filed before your lordships. Any date your lordship will give me.
We find that.
So we will, let us finish the matter. We'll.
I don't want to. I just gave a suggestion. That doesn't matter. We'll do it here, Manas. We'll do it here.
1 week to submit.
It's 2 weeks. 2 weeks.
So let's say arguments heard, order resolved, written submission, they will give submission.
No, Manas. Your lordship will hear us, not reserved, Manas. 2 weeks.
Then hearing.
No, Malas, I'm sorry, I lordship misunderstood me. I'm saying I want to take Malas a little bit of time, have it in the middle of August, I'll finish it off. Any date, one more date. I made this submission only on a remand. Your lordship may
Suggested
hear
by
it
my learned
in
senior
Malas
colleague
couple of
that
weeks
let it go
later,
to
I
justice, the
Malas
way
make
we
sub-
will be bound by that.
I am only asking a date for hearing. Let us not take time on that. Lordship, give me a date, Malas, a couple of weeks later, I will finish it off.
Let the matter heard in part, postpone some to the next week.
Well, good, my lords, somewhere on 19th, etc., whatever suits my lord. Just after the mid-month.
Also, you have argued enough. What-
No, but that's for the remand, Malas. I've got the submissions there to show the error.
Why, we will hear it after lunch, we can hear it.
There may be some difficulty today. Just have it 1 week, 10 days later, Malas. That's all.
Next week, then, because we do, after.
Very well, Malas.
We will hear the matter.
Then
Next week, huh?
fifth-
Order for next week.
good. Next Wednesday,
Wednesday.
Wednesday, obliged. No problem.
Any issue survive now in the matter?
Because a peculiar situation has arisen, the SIT has filed a final
Mike,
report.
use the mic.
The SIT has filed a final report exonerating all three of the accused persons. All three. Despite the young child maintaining consistently before the learned magistrate, the police, the doctors, they have taken a complete U-turn and introduced a fourth person as the perpetrator. So charge sheet filed ignoring all of that, my lords. Your lordships must examine that charge sheet. It has been submitted there. We've been supplied with a
Acceptable
copy.
for us now too. Will be. Can you appreciate the consequences of our examining a charge sheet?
Because I understand the request that I'm making. It's just that because your lordships has invested time in this matter and noted few things in the orders in the past, this kind of an outcome would definitely require your lordship's attention, my lords.
That was.
My lords, I want to draw your lordship's attention to your lordship's order of 11th May 2026, where your lordships have, my lords, looked at the SIT's investigation. Your lordships have expressed satisfaction and thanks to the SIT, my lords. And the real culprit has been found. They have filed a protest petition.
Officers who acted in a very grossest negligence.
Absolutely, my lords.
And we passed strictures against them.
Absolutely, my lords.
And
Absolutely.
thereafter, SIT headed by probably a lady.
Three-
Yes, my lords, 3 top women officers. Yes, my lords.
Absolutely. Your lordship was pleased to appreciate the timely manner in which the inquiry was being done, and that's what's recorded in that order. The investigation, which has now reached a finality, has reached a finality which is absolutely contrary to law and facts, my lords. It's actually amazing how they've done this. 3 persons who have been consistently named.
I know.
Appreciate.
I understand.
We start exercising this jurisdiction of examining charge sheets. Then see the consequences.
I appreciate, my lords, only.
And they filed a protest petition.
That
They've
you have
already
right to
filed.
Submit a protest petition.
Because I must fairly state.
What we can do is that in case you are feeling that in a particular system, you don't have faith or trust, you can transfer it.
Sorry?
Transfer it to.
But we can assure you, I think judicial officers will, wherever they are, they will act in a.
No,
most
absolutely,
fair
my
manner.
lords. One cannot have any quarrel with that issue at all.
If the report comes.
Yes.
The things goes out of the police administration.
Yes, my lords.
Everything comes within the confine of the court.
Yes, my lords.
You have a right to be heard.
Absolutely, my lords. We have filed a protest petition in the intervening period from the last date till today. It is only because of the nature of matter and the time that your lordships have taken, invested in this matter, taken note of the peculiar facts. And this report coming now.
At the time when the investigation itself was being conducted in a
Absolutely.
very shoddy manner,
Yes,
we intervened that.
Absolutely.
It was rightly required.
absolutely, my lords.
Whatever remedial and actions were required to be taken, those were taken.
Absolutely, my lords.
But now when the charge sheet is filed, it may not be.
Because the only request I have for your lordships, what your lordship said, those remedial steps that were taken. Now we have a result which is directly in contradiction to the remedial steps, my lords.
Say at the
Yes.
first line that
Yes,
the victim's family is not fully satisfied with the outcome of the investigation,
please, my lords.
as is reflected in the
Final report.
charge sheet, final report filed in court.
Yes, my lords.
They have already submitted their protest petition.
Yes, my lords.
They direct this is Chief Judicial Magistrate?
Beg your pardon, my
This is
lords?
Chief Judicial Magistrate or?
Yes, CGM, my lords. In Gurgaon, my lords.
We direct the Learned Judicial Magistrate to consider the issues raised
Keep the full designation. Take out the order.
objectively,
Please, my lords.
objectively, and take appropriate.
Mr. Counsel, is it before the magistrate? or
Milos, the
special
session judge, I'll give the details in writing, Milos. I didn't want to interrupt while it's,
Mr. Counsel, is it before the magistrate or the special court?
Milos, it's a special court. I'll give those details in writing, Milos. Yes.
Special court, and we directly let special court to consider those, the grounds raised in the protest position objectively and proceed further in accordance with law. I think saying anything more than that will cause unnecessary prejudice.
Just one more request, my lords. We have not been supplied with the entire record that's been filed along with the charge sheet. That may be given. Certain portions have not been given to us. That may be, at least the complete record may be given to us.
Court will also give, my lords, after the charge sheet. They can take it.
No, it's not been given.
We apply to the special court for supply of the record which, according to them, has not been supplied to them by the investigating agency. The learned court will pass appropriate orders on such since the investigation opening when recent selection of India representative state of Haryana informs that the investigation is complete and charge sheet has been filed.
Yes, sir.
Then say however, the court.
Milos, just to point out for completeness, I'm sorry, as per your lordship's last order, the issue regarding compensation and show cause notices are yet to be considered by your lordships. I'm in your lordship's hand for that, my lords. Compensation to the child and the show, that's between your lordships and this.
My lords, the compensation, the special court can decide. On the show cause notices, I'll assist your lordships if your lordships want to see. My lords, but it will,
Medical?
No, we assist. We have to be good there.
Two issues that are mentioned in para 2 of our order dated 11th May 2026. We request the London Special Court to invoke provisions of the
POCSO
Act
Yes,
Relevant.
and
please.
consider the desirability of awarding suitable compensation
I'll award interim public.
Yes.
and award suitable compensation to the victim, victim's family,
Pending proceeding. Pending the proceeding.
pending the trial.
So grateful.
Next paragraph. Similarly, the issue of negligence for complicity of the medical officers is kept open at this stage. It's kept open at this stage, and the final action shall be taken based upon the outcome of the trial. The trial court finds
Should be done in time.
Yes, can we?
Place it.
Protest petition, we decide in an expeditious manner. Actually, both. Yes.
Yes.
is kept open to be taken up after the trial is over.
And the
Because today we hold cases, then court will have.
No, here the
my lords, my,
Yes.
Negligence or complicity of the medical officers. From a complicity part is left, is kept open.
negligence, only issue of negligence.
Complicity part will depend upon the outcome of the trial. We direct the state government to hold a disciplinary action with respect to negligence of the medical officers.
Departmental justice.
To initiate department to proceed against the doctors who are prima facie found to be negligent in the matter.
Please, Manoj.
Because my protest petition we decided expeditiously, so I'm not.
That your lordships have
Yes,
already
that-
said.
That may come.
That
So great,
trials shall be decided expeditiously.
so grateful.
My lord, may I be permitted to make one submission with my lord's permission? My lord, I am appearing on behalf of the private doctor, the pediatrician, the 70-year-old pediatrician. It is at my instance.
We are only refraining today, not passing a harsh order against you. The way you have conducted yourself calls for a very serious action.
My lord, if I may be permitted to just clarify one aspect, my lord. My lord, it was at my instance that the MLC of the victim was conducted. I was not involved in the MLC in any manner. I am a 70-year-old pediatrician with an unblemished record, my lord. We have filed our compliance affidavit. We are only praying for discharge to be done. We were not involved in the government hospital MLC in any manner, my lord. My lord, even the affidavit of the father records the fact that the doctor was duty bound to register the MLC, even though prima facie there was no evidence of sexual assault.
We are not concerned about any explanation that when the department action is taken, whatever explanation you have, you will render to them.
My lord, I'm only praying for just the discharge of show cause notice to the private
That's
doctor.
why we are not, because the moment we will say anything, it will become permanent on the report. We might give some explanation and to the competent authority in terms of the disciplinary.
We'll examine it.
My lord, all right,
Leave it.
please, my lord.
Manoj, with your lordship's leave, there's
We are grateful, Manoj.
item number 14 is that Shiv Sena matter. 15 is that Shiv Sena matter. Manoj, we are ready. But if your lordships are sitting till for 15, Manoj, is that disqualification and election commission matter, Manoj? We are ready, but if your lordships are sitting till 2:55, and I don't know, Manoj, we are ready. Manoj, we are ready. Will your lordships be taking up a final disposal? Manoj, your lordships are sitting till 2:55. That's why I only asked.
No, if you are ready, then we will also take up the matter.
We are fine, Manoj. Then we are, yes, sir, we are absolutely ready.
But I'm making a request for item 23. That's a fresh IA. It may kindly be taken.
When you come after lunch.
The offense relates to the years 21 to 2025. And the reason for the FIR now is that in the ED's affidavit, there is a disclosure of a cognizable offense. So they have now filed a fresh FIR, Manoj. My request is, can have it tomorrow, Manoj. Otherwise, his bail will be cancelled in the other matters. Yes.
We have filed now.
Now,
It was rejected at 10:30 today morning.
that's why
We have filed a SLP today. Lord, it says that there is an ED affidavit in a pending matter in this court filed 2 years ago. From that, we have gleaned that there is an offense of 2021. So,
21 to 25.
And that matter is under stay.
All right, we will list on tomorrow.
Deeply obliged. Deeply obliged.
Yes.
But make sure that
Give the number.
Yes.
effects are.
Yes, also.
Yes,
Filed an because the judgment is going to be uploaded this evening, so we'll circulate
We
it.
have filed the affidavit, we'll file.
Because the judgment.
I had to circulate, my lord. Without the judgment, we have pleaded for exemption. If the judgment comes, my lord, we will give it.
Give it.
It was dismissed on day one, my lord, today morning.
Deeply.
We have to do that.
May it please, Your Lordship. Well, I beg to appear in IA number 208458 of 2026. And if I may just place a few facts which are relevant for the purposes of the application.
Are you referring to the IA?
Lordship, please. This is my lord's IA number 208458 of 2026.
Two 208,458.
Lordship, please. Your lordships were pleased to pass an order on 14th of July 2026. That order, the text of the order, your lordship will find at page 28.
Paragraph
In
6,
page 3.
Lordship pleases. Page 28, my lords, is the actual text of the order.
Yes.
Meanwhile, as an interim measure and without prejudice to the rights of both sides, it is directed that a separate open space that is adjacent to or near to the subject premises may be provided to the appellant and other members of the Muslim community for offering namaz on Fridays between 1 p.m. to 3 p.m. It shall be ensured that no disruption is caused to either side's ingress and egress to the subject premises while they are performing their respective religious practices. This arrangement shall be ad hoc in nature and subject to the final outcome of the appeals. Now, my lords, after your lordships were pleased to pass an order, we, my lords, orally applied to the collector for the purposes of allocation of the space. There was, my lords, thereafter a representation on 17/7/2026 by a group called Maharaja Bhojshala Sanstha Samiti. That representation your lordship will find at page 30. Please have that representation. And this was made to the collector. Your lordship has, my lords, the first paragraph, just about 6 lines from the bottom, my lords. Bhojshala is a protected archaeological site. Your lordship has that. Justice Bagchi has that, my lords, at page 30. Yes. Bhojshala is a protected archaeological site with a 100-meter restricted area and 300-meter regulatory area. As per the Archaeological Survey of India regulations, where any activity is prohibited, activities such as namaz near the protected area of this sacred and educational temple complex within survey number 1 have the potential to damage its sanctity and archaeological character. Then, my lords, para 1 is, my lords, a reference to order of the High Court. Paragraph 2 is a reference to your lordship's order. And then come to paragraph 3. To perform this separate open space should be provided located at a sufficient distance from the protected Bhojshala complex. It should also be ensured that Hindu devotees do not face any disruption or obstruction in their right to enter and exit the Saraswati temple for daily darshan and worship. This arrangement will be purely interim in nature and will remain subject to the final decisions of the appeal pending before the Honorable Supreme Court. And then, my lords, it says, it is a humble request to you, sir, that in order to maintain public sentiment, historical facts, archaeological evidence, and communal harmony, and to maintain law and order, in compliance with the order passed by the Honorable Supreme Court, the Archaeological Survey should direct the people to offer namaz in a separate and open additional space located at sufficient distance from the projected Bhojshala complex, other than the protected Bhojshala complex of Ma Saraswati, protected by the Department of Archaeology. So the representation is in the teeth of your lordship's order. Now kindly see, my lords, what the collector does. And it is this order which is impugned in the eye. Page 33 is the order passed by the collector. And your lordship sees the last paragraph at page 33. A separate open space located at sufficient distance from the Malords, at page 33, Malords. The last paragraph.
A separate open space.
Lordship, please. If I may read that, Malords. A separate open space located at a sufficient distance from the protected premises should be designated for the purpose of offering namaz. It was also demanded that no obstruction be caused to the rights of Hindu devotees to visit the temple for daily darshan and worship. At the meeting, the appellants and the Muslim side suggested that the space to the right of the main entrance of the building, where the community previously performed ablution, adjacent to the Khilji Dargah may be made available for namaz. They were informed that if this space was made available for namaz, separate entry and exit routes were not available for both parties to perform their religious rituals. In such a situation, maintaining peace and order would be impossible, but the Muslim side offered no other alternative. In the light of the Honorable Supreme Court's order dated 14/7/2026, in SLP number so-and-so, the reports of the Subdivisional Officer Revenue of Dhar and the Tehsildar of Dhar district, the suggestions and objections presented at the meeting between the two parties, and the commitment to maintain peace and order in Dhar district, it has been decided that land in survey number 664, admeasuring 0.455 hectares, located at such and such near Bhojshala, is the most suitable land for the appellants and other members of the Muslim community to offer namaz. This site is a separate and open space where namaz can be offered, and there will be no obstruction to entry or exit. Now, incidentally, my lords, we then make a representation, of which your lordship will see the extract at page 35, that this is neither near nor adjacent.
How far is this Malliwada?
Yes, it is approximately, if you go by Google Maps, it is 1.3 kilometers. You can't see the mosque from there. Point number one. If you go by where the crow flies, that is radius, then it is approximately 0.9 kilometers. So this is what is being offered. Now, my point is only one. After hearing all of us at great length, your lordships were pleased to pass this order. In fact, I had pressed for an absolute stay of the order, and I had said revert back to the position that was obtaining for approximately since 2003. That is to say, Friday's namaz we do inside and they do puja on Tuesdays, because that order endured from 2003 up till the disposal of the writ petition. Your lordship said you lost in this petition, but in the interregnum, we'll pass this order saying adjacent, you will get space. Adjacent space was made available earlier, where, my lords, on one particular occasion, your lordships remember when there was a huge congregation. At that point during Basant Panchami, your lordships had made an adjacent place available. It was also outside the complex, not within the complex, though your lordship's order said within the complex, but they gave it to us outside the complex. We performed Friday prayers there. There was also a contempt file, which is pending, saying that they didn't give it to us inside the complex, be that as it. Now, my lords, if I may just to work this order out, I had given, my lords, the collector a map, and I had suggested to the collector 4 adjacent open spaces around the complex, all of which are Waqf land. None of them, my lords, are privately owned lands. And I have an affidavit, my lords, from the Mutawalli that we have no objection if you perform namaz here. Just hand over that compilation, please. And then, my lords, today in the morning, at around 10 o'clock, we were served with a note. Why, my lords, these particular adjacent places?
Do we have any site plan or sketch plan?
I'll give that. I'll give a site plan as well. But just for the sake of clarity, and because I don't want to quibble over whether my site plan is correct or theirs is correct, yeah, just give the citation. Now, my lords, your lordship first asked me a question which I have addressed. Just see page 1 of the compilation. This shows that the existing place that they are seeking to allot is approximately 1.3 kilometers away. So it's clearly unsuitable, doesn't comply with your lordship's order. Now, my lords, kindly see page 2. Does your lordship have it? Yeah. And then I have a zoomed in map, which I'll refer to. This is the map. This is a map prepared by the collector. Give the other side. Just give it. This is, my lords, a map prepared by the collector. Now, my lords, if your lordship sees the portion in the middle, just before the arrow, does your lordship have that, my lords? That is the entire Bhojshala complex. The portion, my lords, which is bounded by a wall. So, which is white with red. Your lordship sees that? So, my lords, even as per their writ petition, one second. Even as per their writ petition, my lords, Their claim is with regard to the area inside. Because they say that we have a right to enter and worship inside. Now, my lords, just come to the next page. There's just a zooming in of the map. And your lordship will come, leave the next 2 pages and come to page 5. Which are the alternative sites which are available? So, adjacent to the Bhojshala, your lordship sees the first portion where your lordship will find that your lordship may see later, my lords. I'll take your lordship for that. On the right-hand corner, my lords, may I proceed?
Yes.
Lordships. Now, my lords, your lordship sees first the area which is marked in pink. Page 5, my lords. Does your lordship have? Page 5. My lords. Does Justice Bagchi have page 5? I'm obliged to your lordship. Page 5. The area which is marked in pink. This is, my lords, one portion of land which is available. This is, my lords, Waqf land. This is Dargah land. Then, my lords, next to it, immediately abutting the complex, is, my lords, a Dargah. Your lordship sees the 2 domes. This is not within the realm of controversy at all. Just abutting the Dargah, you also have Dargah land, which, my lords, I have bounded in orange. Does your lordship see that? The orange block is also Dargah land. Even though, my lords, this is not as proximate as the pink block, let's still say, all right, I'll take that. The third portion, my lords, there's a cinema hall next to it, which is all in green. This land, my lords, is used because, my lords, an objection is raised of ingress and egress. So this land was used for ingress and egress for coming to the Dargah. And there is a gate at the orange line that can always be used, and it can give, my lords, a separate area. Fourth, my lords, your lordship sees there are green fields on the extreme left. Your lordships have seen that, my lords? On the extreme left, which I have, my lords, marked in yellow.
Yes.
This is also Dargah land. So adequate amount of space is available. Now, my lords, the reason that they give, because I suggested, give me any of these 4 plots, so that, my lords, I can offer my prayers there in compliance with your lordship's order. So now kindly see, my lords, what they circulated to me at 10:30 in the morning today. And that is really, my lords, I submit, my lords, as an officer of this court, with the greatest respect, I feel appalled. Now just kindly see that. I'll also hand over this site map. Yes. Just one second. Just wait. Now 602 will be what over here? 602. Over here will be. No, what over here? What is 602? Yes. Now, my lords, this is what was circulated to me in the morning. Now, what they say, why they can't allot the adjacent land. 602 cannot be given for offering namaz. The said Khasra survey number is recorded in the Khatoni land records as Waqf land. The said Khasra survey number is adjacent to the Bhojshala complex and is situated at a juncture where providing for the said Khasra survey number for offering namaz would lead to a problematic law and order situation, necessitating deployment of large police force to maintain law and order. The said Khasra survey number is situated adjacent to one and only entry gate of the premises in question, and making it available for namaz would leave only a single shared route of ingress and egress for both communities. Now, first, it is admitted that it's Waqf land. So I am being told that even on Waqf land, I can't offer prayers. Please bear that in mind. Now see the next one. What this? 603 cannot be given for offering namaz. The said Khasra survey number is recorded in the Khatoni land records as Waqf land. The said Khasra survey number is adjacent to the Bhojshala complex and is situated at a juncture where providing the said Khasra survey number for offering namaz would lead to a problematic law and order situation, necessitating deployment of large police force to maintain law and order. The said Khasra survey number is situated adjacent to the one and the only entry gate of the premises in question, and making it available for namaz would leave only a single shared route of ingress and egress. Then the next mullahs, again the same template is followed, that there will be a law and order situation. Just see 3 mullahs and 4. Now, I only wish to point out as to why this particular excuse of ingress and egress is wrong. May I point out why? Just see, my lords, first, when, my lords, we were allowed to offer prayers on Friday earlier, your lordship sees page 2. This is a map drawn by the collector. There are 2 arrows on the map. On one side, you see an arrow which says Muslim at page 2, my lords. It's in Hindi, my lords.
Page 2.
Page 2 of the compilation. Page 2, my lords. It says, my lords, Muslim. Your lordship gets that? The arrow. So we were allowed entry from here. There was also an entry which I pointed out, my lords, through the cinema. There's a gate over there. One can also come into this particular area from there. No difficulty. So we were allowed that time entry, my lords. Your lordship sees the cars parked from the middle of where the cars were parked through the gate, and then we walked in to, my lords, where that arrow is. There is no ingress and egress. So far as, my lords, the other community is concerned, your lordship sees the extreme right hand side. This is also Waqf land. They entered from there, my lords, went straight and came from this particular area. This is actually the entry to the Bhojshala complex, and they were using it. So therefore, my lords, this entire excuse of saying that ingress and egress there will be a problem is, in my respectful submission, a moonshine. Now, my lords, I come to the other reason that he gives. That is apprehension, my lords, of a law and order problem. So I am being told that on Dargah land or Waqf land, I can't even offer my prayers. Now, your lordships have already seen, my lords, the topography of the area. For time immemorial, this complex, the Bhojshala complex, which was the Kamal Maula Mosque, and, my lords, the Dargah of Khilji, has coexisted for time immemorial without any problem.
Do we have any site plan, bigger site plan,
Yes.
showing the approach road to reach all these sites?
Mulans, I have the best that I have, because once I draw a site plan, they'll dispute it. So the best that I have is what the collector's office gave to your lordships earlier, which is a matter of record, to say we'll provide for a separate entry and exit. So that is the best that I have is at page 2. Now the difficulty is this, Mulans. What your lordships are being told is, and my lords, I don't want to get into press reports, etc. In fact, I have instructed my client very strictly, don't go to the media. But there are, my lords, overarching press reports which very clearly say we will not allow them to perform within 300 meters. And that is what, my lords, the collector. This is, my lords, there's a phrase, my lords, which is used in American jurisprudence. It's called the heckler's veto. It is called the heckler's veto. That you will create when, my lord, someone's free speech is thought to be interrupted by a mob and you are being told that now silence the person speaking rather than protecting the person speaking. I also have a right of freedom of expression in terms of my prayer. Merely because someone threatens a law and order problem, your lordships will not yield to it. So there is something, my lords, much larger at stake, apart from the fact that it is your lordship's own order, which says adjacent or near to. So there are three decisions, my lords, which I'd like to bring to your lordship's kind notice to say that the collector must give any of these three adjacent places once there is your lordship's order. May I cite, my lords, three decisions which say you can't really yield to the wrongdoer. I'll start, my lords, with 1982 1 SCC, page 71. Just give a copy, please.
Do we require case law? Point is only, we have passed an order.
Yes, my lord.
We are only one issue of compliance of that order.
Yes, so my lords, so my lords, then so far as if your lordship is seeing it from a narrow perspective,
Now we are saying we require too many police personnel for that. The issue is the decree does not injunct holding of namaz in and around the temple. The decree is with regard to use of that people for religious purposes. Now, if adjacent to the temple, there is
problematic area appears to be. This is all very difficult temple. Only to control this crowd. So that there may not be stampede. You'll see the full of crowd. Additionally, this can be illegal selection. But for this, we do that. For entire,
this no, you can see are quite reasonable.
please.
Which of these pink, orange or blue?
I beg your pardon.
Which of your page 5?
I am obliged to you.
Yellow, orange or blue
Yes, ma'am.
sites was used on the last occasion when the suit
Yes.
was pending for the purpose of
Yes.
holding namaz.
Now, what was used, my lords, only for that one Friday, because it fell on, that is, my lords, your lordship sees the arrow which says Muslim. Pink. But that also, my lords, was not in compliance with your lordship's order. Yes, that is what was used. Straight answer is that is what was used.
नहीं पिंक गलत बता रहे हैं पिंक नहीं यूज हुआ था वो गलत बता रहे हैं पिंक नहीं ये कह रहे हैं नहीं यूज हुआ था ये नहीं यूज हुआ तो यहाँ परफेक्ट है
Favorable to the yellow land.
My lords, I will agree to whichever one, my lords, your lordship thinks appropriate. I am not, my lords, yes,
You're asking,
I am obliged.
trying to find out.
clarity.
Page 5, my lords, yes.
You have put in yellow, pink, orange and blue.
Yes,
Yellow is this open field.
yes, I am agreeable to.
So agreeable.
I am agreeable.
And Mr. MD,
And what is their response to that?
first you are asking for a bigger sketch plan or site plan.
So this is, my lords, the sketch plan, this sketch plan that I have given. Is only to show, you should see that sketch plan,
Find out why.
Lordship, please.
Because if to this side, which will be yellow pencil side, if there is a separate access road to come to that side, that's
There
where
is
they
none.
can come in.
There is none. The road is, my lords, on the left-hand side.
So
Your lordship sees the first.
land is adjacent to the road.
Yes. Now just see, my lords, on the left, my lords, the first, page 1, my lords. The initial road through Google Maps, my lord, it goes in a sort of a U.
Did you offer that yellow?
Sorry, my lord. Yes, we did.
What is the
Yes.
state's response to the yellow?
To the yellow, my lords, the state's response is
Site number is?
the site number
Which you have
of the
given?
yellow
Site number.
would be, now be sure about it. Which is that site number?
Only then you will be able to say which number.
596. This.
No, but tell me here, which is that site?
As per the state's response, which category is the yellow plot?
They haven't discussed that. They don't seem to have discussed that in this chart.
Tell us what is the number of that portion from your table.
My instructions are, my lords, it is, are you sure?
You sure about it?
My learned friend can, my lords, correct me. So I state this on instructions. It is Khasra number 596. 596.
There is no response.
No, he is asked. See, his lordship is asking you a very simple question. Please understand. We should be clear on facts. Yeah. That this area, this green area.
Why we ask you is you
Yes.
offered 4.
Yes.
If you are not wrong, 4 alternate sites.
Yes.
Which, without going into the issue whether it is in strict compliance or not, you may be agreeable,
Yes.
subject to your further.
Yes. Because we want to pay also obeisance by looking at the mosque also.
Absolutely.
Lordship.
Now, there are 4 sites and one is yellow, one is pink, one is orange, and one is blue.
Lordship, please.
Now you have pointed out to us that the state has given an objection to all these sites.
Yes.
So we want to know which of these objections relate to the yellow side.
Yellow line.
They don't say anything about the yellow
The
side.
yellow side was not perhaps offered to them.
Then yellow can be offered.
Yes, it can be.
Mr. Nataraj, are you appearing for the state?
Yes,
Please unmute yourself.
Yes,
And
can I
Manoj,
put the,
just, if I may just finish with two other sites were offered. I just wish to point that out. Just, my lords, so that Mr. Nataraj can respond in a wholesome way. Where is my thing now? No, I want the note. Of that very note. No, not that. my lord. Your lordship has this note, my lords, which the state gave us. The chart, my lords.
You are referring to this one?
I'll just refer to it. I'll just come to that. If your lordship just sees this chart.
This was the yellow Khasra?
596.
596. No response in this sheet, sir.
596 is here, next to the road.
Next to 603.
596 we do not vote. This 596 is this one. This one 596. This one. So just find out 596 kaisa hai.
Two sites.
We are going into that. We are exploring the possible
Yes.
convergence area.
Yes. So one, my lords, I'm only trying to say there should be really a little sense of some sensitiveness.
In this plan,
Yes, my lords.
in this appears to be Akshadra.
Yes.
Maybe Akshadra or maybe.
Yes, that's my lords. From government records, my lords, we have drawn the site position.
This 509 is far away.
596.
596. my lords. Yeah. 509.
Offered by the state.
What the state has offered is in green, my lords.
50 kilometers away.
Yes. What the state has offered is 639, 509, 664.
Five zero nine six nine are offered by.
Yes, so 509, now they mentioned it, I'm going by their statement, is 500 meters away, half a kilometer. Half a kilometer. And my lords, 509 is actually in an old brewery or a distillery or something like that. I'm only 509 is in an old brewery or a distillery.
And 639?
639, my lords, they say is 500 meters.
That is
It abuts 509.
It's empty. They are saying the land is flat and empty. It is suitable for opening Nawaz. They are not saying any distillery or industry.
Yes, but there is, my lords, I have a video also of that entire site. But anyway, either adjacent nor near. No, I'm respectfully, my lords, I respectfully.
If it is not otherwise suitable, it is not suitable.
Yes, my lord.
We are only saying that that apprehension may not be.
It is.
Suppose the site is suitable, but the site is being used for something that has to be,
Yes.
But they say no, it is flat, then it can be resolved.
But it is not, my lords, something that is either near nor adjacent. So therefore, my respectful submission is that it does not really fall in accord with your lordship's thought.
What about 639?
639 is also very far, my lords. 500 meters. And by road, it will be much more because it is 500 meters by radius. If you go by road, you'll have to come back to the road and then go. So they are also, when they write the distance, they are measuring by radius as the crow flies.
So, you can ask Krishna Natraj. Krishna Natraj,
Yes, yes, please.
there are 5 numbers
Yes,
which according to you cannot be given,
yes.
right?
Now, can I make two submissions before getting into these aspects? As a state, I do not want to get into the respective rights of two parties. Two competing parties are claiming certain rights. I do not, as a state, I do not want to get into that. Number one. Our only concern is about the law and order issue, which we are required to look into that. And beyond that, I do not want to go there. That is my.
Mr. Nataraj.
Yes, that is the first statement. Kindly.
Of the state.
Yes.
Every
Yes. Now.
community has a religious right, and
Yes.
proper performance of religious right and to maintain
Yes.
law and order is one of the constitutional duties of the state.
Correct. That's all we are concerned about. Therefore, now we have assessed about 9 sites as per the list. Out of it, kindly have that list which is already given to my learned friend and the copy of it. Out of which sites number 1 to 6 in the particular list, for certain reasons we have given that may not be more suitable for offering to the other side. That is the stand taken by the state in the present circumstances. However, site number 7, 8, 9 in the list, serial number 7, 8, 9. These are the 3 sites which can be offered. That is the comment what I have received from.
Does the decree pass a mandatory injunction on namaz in and around the archaeological site?
No, that's what. Just let me complete. Kindly bear with me for a minute. Let me complete. So, in our assessment, we said about 7, 8, 9. They would be that can be offered. That is the first statement we have made. In addition to that, today he pointed out about survey number 596, about which we have not taken any stand as of not. We have not verified that particular land because
Very short now. There are 5 sites which according to you cannot be offered, cannot be given. All right, we accept that. 2 sites according to you can be given. That is not acceptable, so we ignore that also. Now 596 is the site which is otherwise recorded as Wakaf land. As Wakaf land.
Yes.
It is on the rear side of this Bhojshala. It is on the rear side. The site Akshadra or whatever the site plan given to us, that suggests that it has a separate independent entry also. Access road is also separate. So
On, yes, on yes, on 596, I am yet to take any instruction on particular survey number because today it is offered to this one, the particular survey number is given to me 596 today. Otherwise, it's not part of my list in serial number 1 to 9. If I can take instruction about 596.
So what we direct to you is that you offer them
Yes.
596.
Yes.
Provide a separate access and so that you don't have that landowner issue. And in case you find any difficulty you experience, you report to us. We will request them.
Very well, very well, very well, very well. That can be made. That would be fine. I think that would solve the problem.
Let have it tomorrow, Manoj. And your lordship may say 596/611 because part is 596, part is 611. They just abut the road. So there'll be no problem of ingress and egress.
We are directing 596.
So part is 596, part is 611. Correct, Manoj. So part is 596 and part is 611. There's a slight, because the khasra overlaps, Manoj.
The road. See and examine.
Recorded in the
Yes.
Wakaf.
Even if it is not Wakaf land, 596 is a vacant land.
Vacant
It
land.
should be offered. That
Yes, Manoj. It's a field.
Even one more instruction.
According to us,
Mr. Ahmed, are you sure it's a Wakaf land, 596? If it's a private land, you have no, you'll go.
no, we have said Dargah land. Manoj, in the map that I have given to your lordship and I have marked, I have said it's Dargah land. Or otherwise, Manoj, their only objection to even the.
Pass an order on a land of a person.
Yes, certainly.
Not before us.
I am not saying that.
private land.
Yeah.
It is a government land, no difficulty.
Yes, if it is government land, vested land or Dargah land, we can pass an order.
My instruction
If it's a
is
private land.
that it
Show us
is
this
Dargah.
land and we allow you to hold namas. It's going to be including into individual.
Why have you said Dargah land in the map? Other than that, that's all.
Must be sure of the.
Yes, Manoj, the yellow portion that I have marked may be part 611 and part 5. It's Dargah land. Those are my instructions. I state on instructions, Manoj, I don't. Yes, I am instructed, Manoj, by my instructing council.
They should live by page 5, not by the.
So the yellow portion at page 5.
Known as Dargah land.
Part is 596 and part is 611. Yes.
At the same time, I have instructions subject to it is acceptable to the other side. We as a state will try to find some even private land if we can for a temporary period nearby place. If we can negotiate with them. Yeah.
Mr. Drag, if you find out any other site which is acceptable to them, no difficulty.
Yes, that's right. That's right. We want
that, you can always resolve it. If there is some better site, Mr. MD, which community.
Correct.
Yes, my only Manoj's anxiety is it should be either adjacent or near where we can see the mosque.
What Mr. Bhagwat says is, this order should not prevent them from negotiating with you, and if they get a better land acquired from the private owners also.
Correct.
Yes.
Yes, if we as a state will negotiate and we'll try to get it.
That's always.
Yes, that's always possible.
But
I want to put a very amicable end to this particular pause for the time being. That's all. We want to put an amicable pause to this one. That's all our end over.
Order 14 July 2026. We have heard.
First, specifically say that the number is she's got instruction from the.
So you, I am the non-senior counsel on behalf of the applicant appellant. As additional services and India. On behalf of the state of Madhya Pradesh. Representing the state of Madhya Pradesh.
May I just, before your, sorry, Manoj, to enter that. Just one.
Paragraph 6, so.
Just one request, Manoj.
The order dated 14 July 2026 is further clarified to the extent that the of the Muslim community be permitted to open namaz on Fridays from 1 p.m. to 3 p.m. at the land hearing number 596, which is reported to be, which is stated to be Dargah. From the copy of the Akshazra site plan produced during the course of hearing, it might appear that the above Akshazra number has an independent and separate access road, and therefore the said site appears to be suitable from the point of view of land is adjacent to the subject premises and is thus suitable
And appears to be suitable
and
for all,
appears to
from
be,
all purposes.
and appears to be suitable from all purposes. From all. Next paragraph. However,
611.
That's okay.
616 we should.
order shall not preclude both sides to select any other alternative site on the basis of mutual consent. Or this order shall not preclude the parties to opt for another site by mutual consent. Order to court.
May I just make one respectful submission? Your Lordship may in the order say, Your Lordship has mentioned the numbers. Your Lordship may just also clarify that the site mentioned in yellow at page 5. Because suppose today there is some slight this thing with regard to some khasra number, it's all Dargah land.
Which depicted with yellow dot line in the Google map, Google image number 5.
At page 5.
At page 5 of the application.
Of the compilation.
Of the compilation. Of the compilation referred to during the course of the
Lordship, please.
IAS Council Stand 20855 of 2026 and disclosure for
Would your Lordship keep it pending rather than disposing it of today? Because if they don't allocate,
Then come for modification.
You can always file another
Change in site or something.
the difficulty, your Lordships have said that they will allocate this particular.
We have said it's suitable for all purposes.
Yes. So we can meet the collector today evening. Let the collector give us an audience.
We have directed the allocation of that land. What we have left open is only for any other site by mutual consent.
Yes, certainly. If we mutually agree, fine. Maybe meet the collector today, let him give us an audience today. Because tomorrow is Friday.
It shall make necessary.
The state authorities are accordingly directed to make necessary arrangements.
Please, we'll do it. We'll do it. Please.
But I just wish to point it out something that in this SLP I am not party, and this has been made a lead matter. I have filed an impediment application as certain things I wanted to point it out. Not I have not been made party in the entire SLP.
But
And it has.
then it is a suit. You are not a party in the suit.
No, I'm the party in the suit. Yes, I contested.
Notice will always go to you.
No, they have not made me party in this SLP, and this is a lead matter, and the other connected matters are not listed. Lords, whatever documents have been filed, shared, I have no information, my lords. I just came to know that this, they did not make me party in the SLP, my lord. I have contested the matter throughout in the High Court, my lord.
All right, you can apply to become party member.
Make necessary corrections, all parties should.
No, he was not a party in our writ petition. So I couldn't have made him a party in mine.
There may be others.
The lead matter.
And as your lordships are aware, there is no suit.
The
Here,
writ
here
petition.
it's a decree in a writ.
Correct.
Lordship.
True.
I wished, if lordships permit, I just wanted to.
Difficulty, if you are a party there.
Yes, Malad, may I just say one thing, Malad?
You are most welcome.
I'll say, if I say something in my learned friend's favor, I will never stand on technicalities in a matter like this. Your lordship may say on my oral application, he should be made.
But then, my lords,
Only the application which.
certain,
No, I'm saying on my oral application, make him a party, no difficult.
Also, at the outset, the MP suggests that on his oral prayer, so and so may be named as a party.
Let him supply the details.
The prayer is allowed until the order to be executed as listed in this one. Then the citizen accept notice on behalf of the newly added respondent. And the party may invite to and then he remaining.
my only, my lords, request was that certain issues I wanted to, my lords, highlight, but I couldn't highlight. Certain issues I wanted to highlight, I couldn't highlight one.
Finally.
Because, my lord,
The interim arrangement, ad hoc arrangement, final hearings.
Please, MP.
Yes, Mr. Sibal.
I'm grateful.
Which one you? Is the kabaddi.
15 is a single. I'm speaking to people.
That's the sets of petitions.
Yes, Manoj. Manoj, there are two sets of petitions. One is qua disqualification. The other is the allotment of the symbol. Before we go into that, let me give your lordships a bird's eye view of what the issues are and why we are here, Manoj. Manoj, Bala Saab died in 2012. And Manoj, in 2013, Manoj, Uddhav Thackeray became the Paksh Pramukh of Shiv Sena. And Manoj, the organizational structure of the Sikh Sena was set up at that point in time. And that organizational structure was amended in 2018. And Manoj, in terms of that, as your lordship knows, Uddhav fought the election and Eknath Shinde was part of that. In fact, he was a group leader. In 2019, Manoj, the election we won and he became a minister. Then, Manoj, what happened was that there was an election of an MLC, in terms of which, Manoj, some cross-voting took place. And suddenly, Manoj, 31 members.
Election of, you were saying election of?
MLC, Manoj. MLC, some cross-voting took place, Manoj. I'm just giving you lordship brief ideas to what we're dealing with. Some cross-voting took place, Manoj. And in terms of that cross-voting, we suspected that Eknath Shinde's faction was responsible for it. But suddenly we found, Manoj, one particular day, Manoj, that 31 MLAs, Manoj, shifted to Surat.